All right. So good afternoon, everyone. And I guess good morning if you're west of the Eastern time zone. This is the first of what we expect to turn into a regular series we're referring to as 10 Minutes on Tax. The idea here is to socialize some of the conversations we're having with our clients that could be applicable to a wider number of the members in our service network. I'll start all of these calls with a quick intro and a disclaimer for any newcomers or people that haven't met me before. My name is Kevin Zeman, and I'm the leader of the tax services practice here at Gen2. Our work focuses entirely on tax services for private equity fund clients and their GP and management company vehicles, which is largely going to be the topic of today. I do need to disclose off the top, because we have lawyers, that Gen2 is not a law firm, and this presentation is not intended to be legal or tax advice for any of your particular circumstances. We encourage you to reach out to us or your tax or legal advisor if you have any questions. But for those of you that know me, I'm happy to talk about anything with you, so don't hesitate. We'll put up our contact info at the end of the session if you want to reach out. And as one kind of housekeeping note, we always appreciate when you send questions in advance. A few of you have done that already, and we're going to try to address some of those things as we talk today. All right, that out of the way, why are we here? In November of 2023, the tax court issued a ruling denying summary judgment in a case called Soroban Capital Partners v. Commissioner. This was a case that involved the limited partners claiming an exemption from self-employment tax on their earnings from the investment fund. It is a procedural ruling, right? It was a summary judgment ruling. But since it came from the tax court, it's precedential. And the court concluded that in order to determine whether partnership distributive share is subject to self-employment tax, we must actually test the partner's role in the partnership. Now, what exactly did the court say? They said that in order to determine whether a partner was a limited partner, right, the IRS disagrees with the premise that solely because it's formed as a limited partnership and a partner is a limited partner for state law purposes, that distinction automatically excluded the distributive share from SE tax. What didn't the court say? The court didn't say that it must be subject to self-employment tax, and it didn't say that you must either be subject to self-employment tax or exempt, right? They kind of endorsed a hybrid approach. Also important, since this was just summary judgment, they didn't actually apply a functional test, as was referenced in the Soroban case. They simply said that there needed to be one in order to address the tax effect. What does this mean going forward? Well, in order to gain some insight into where things might go, it's helpful to take a quick look at how we got here in the first place, right? And I'm always told not to refer to tax code sections in mixed company. So I'll only do it a few times, and I'm going to do it right now. So Section 1401 adds the requirement that there be a tax imposed on self-employment income. Functionally, being where it is in the tax code, this is the self-employment version of FICA tax, right? It's generally used to fund Social Security and Medicare and to qualify for payments out of Social Security and Medicare. That's important because 70 years ago, when Congress wrote the law, they were much more concerned that the Social Security rules would inadvertently bestow benefits onto limited partners on their passive investments than they were concerned that people would avoid paying self-employment tax. In order to address their concern, they wrote an exception into 1402A13. That exception says, and I'm paraphrasing for the most part, there shall be excluded in the inclusion of income for self-employment purposes the distributive share of income of a limited partner as such, other than guaranteed payments described in 707, right? Now, the service and the tax court are raising the question in the Soroban ruling if they're changing their position on being more concerned that by closing the Social Security benefit loophole, they actually created a much bigger self-employment tax loophole. And you'll note that the language of the exception in 1402A13 says a limited partners as such. Unfortunately, a limited partner as such isn't the type of thing the IRS wants to define specifically, because then everyone will go right up to the line, right? It also seems like they had a lot of, their motivations for writing the law at the time might not have clarified that they needed to. To this day, they really haven't defined what limited partner as such means. They have, however, gotten close a couple times, though none in recent history. First, with regulations in 1994 that were subsequently withdrawn. Apparently, everyone didn't like that. And then again, they proposed regulations in 1997, and Congress liked it so much that they passed a law forbidding them from finalizing the proposed regulations on the treatment of LP income. Those regulations are technically still proposed, and the moratorium of finalizing them has passed 40 years ago, but no action has been taken since. In an indication of what the IRS is currently thinking on the matter, the tax court in Soroban did give deference to a previous decision in a case that is Renkemeyer, Campbell, and Weaver, LLP versus Commissioner. In that case, it was a law firm that was organized as an LLP. And all the partners claimed, the exemption from self-employment tax on the basis that because it was a state law LLP, they were state law limited partners, that de facto made them limited partners for tax purposes. In that case, the tax court disagreed and said that because they deemed the compensation to be received in services performed on behalf of the firm, as opposed to a return on investment in the firm, it should be subject to self-employment income. That gets us back to the Soroban ruling, which referenced that ruling as its basis, right? And says, okay, well, where do we go from here? While there is no single interpretation of the self-employment tax exemption to LPs, limited partnerships in general, or really to investment funds, it's at least worth considering whether the Soroban ruling creates some risk management discussions, right? We see many funds structured to accommodate the limited partner treatment. We see many, the full range of positions on how you want to treat your employees or your partners, particularly at your GP and management levels for SE tax purposes. There's some analogy here to the as such term by looking at state laws, right? Generally in those cases, it's a piercing of the veil type argument where are you still exerting the right control or influence or too much such that you lose your limited liability. The gray areas here always seem to fall toward the exercise of control over the business, the roles and responsibilities, and in some case, including the 40-year-old proposed regs, right, the amount of time spent. This probably warrants at least some discussion internally on tasks like signing authority, management authority, even titles in some cases. Now, what's the most common thing we're seeing? So far, the response that has been most common has been a wait and see approach. The reason firms are making this decision, it seems to us, and these are observations, right? Even though the decision does create precedent because it came out of the tax court, it is not the final disposition of the case. This case was a summary judgment ruling. The case is still proceeding. There has been, discussion that the appeal is coming to the summary judgment ruling, and for all I know, might have been filed already, right? Also, I should note that there are a couple of additional cases in circuit courts that are addressing this issue as well, and those can certainly come down on the other side and change the outcome of this case or muddy the waters even further, right? Whatever the outcome, though, I think it's worth noting that in the 2023-2024 priority guidance plan for the IRS and Treasury, this was specifically identified as a topic that they wanted to address. That tends to give you an indication that at least the rulemaking bodies are thinking about it. And it's possible that the favorable ruling that the IRS got in Soroban might boost the timing or accelerate the timing in which they try to get rulemaking done, especially if there's going to be some change resulting from, the administration and an election. I think that's high level what we're seeing now and what we wanted to make sure to share with you. Again, if you have questions or specific circumstances related to your fund, feel free to reach out and contact me or any member of your Gen 2 service team. And we're happy to address any of your concerns and hopefully work with you to either create a risk management plan, make some changes to your operations, or at best, just make sure we know you want to be updated. And I think that's a little bit more than 10 minutes on tax, but we'll see you next time with the next update.